Hey guys, welcome back to the channel. This is the House of Law and I'm Attorney Al Jimrani. In this channel, I make videos about the law, about law-related issues, and about law subjects. So for today, I'm going to make a lecture video. It's been a while since my last lecture video because in the past few weeks, I've been making video case digests of the Justice Leonen civil law decisions. So pahinga muna tayo dun. But today I will make a lecture on civil code, general principles, and human relations. So if you are a first-year student taking up persons and family relations, or a fourth-year student taking up Civil Law Review 1, or a bar reviewee preparing for the bar, then this video is for you. So sit back, relax, listen, and learn. So let's begin. Welcome back. So let's begin. This is General Principles, Effectivity and Application of Laws, Judicial Decisions, and Conflict of Laws. Now, this lecture will follow the order of provisions in the Civil Code. So, to be exact, we will only be talking of Articles 1 to 36 of the Civil Code. So let's start. What is Article 1? Article 1 provides that this act shall be known as the Civil Code of the Philippines. The Civil Code of the Philippines took effect on August 30, 1950. So, August 30 lang ah. So, ilang taon na ang Civil Code? 71. So, yan. 71 years old na po ang Civil Code. After celebrating its 71 years last August 30. Now, the Civil Code of the Philippines is Republic Act 386. So, it was a law passed by Congress, signed by the President, but the draft of the Civil Code was, of course, prepared by legal luminaries such as, including Senator Arturo Tolentino and Justice Francisco Capistrana and others. Okay, so you can really see, the legal knowledge, the depth of legal knowledge, okay, put in this Civil Code of the Philippines. All right. So speaking of effectivity, Article 2 provides that laws shall take effect after 15 days following the completion of their publication in the Official Gazette, unless it is otherwise provided. This code shall take effect 1 year after such publication. Napansin nyo ba, Article 2 only provides publication in the Official Gazette. Okay, so meron bang may kopya ng Official Gazette sa inyo? I mean, have you ever seen Official Gazette being sold anywhere? Okay, so that posed a problem. So that's why EO number 200 dated June 18, 1987 was signed by President Corazon Aquino, and in that it was provided that law shall take effect after 15 days following the completion of their publication either in the Official Gazette or in a newspaper of general circulation in the Philippines unless it is otherwise provided. So now laws can be published in either the Official Gazette or in a newspaper of general circulation, because we have to admit, Official Gazette is rarely published, and if it is published, the readership is very low. Unlike newspapers, more or less you can expect that these newspapers will reach even the most remote places of the country and will reach people or Filipinos of all ages and of all walks of life. So kaya a law can now be published in either. Okay. Now, when a statute does not explicitly provide for its effectivity, it shall have effect only after the expiration of the 15-day period following the completion of its publication, either, again, in the Official Gazette or in a newspaper of general circulation in the Philippines. So take note also that publication must be in full, or it is not publication at all, since its purpose is to inform the public of its contents. That's why it's not enough that only the title or even the summary of the law should be published. It should be the entire text so that we know what the law is about, and with that we are able to comprehend and of course follow the law. Now, the clause unless it is otherwise provided solely refers to the 15-day period and not to the requirement of publication. Publication is an indispensable requisite, the absence of which will not render the law effective. If the law provides for a different period shorter or longer than the 15-day period provided by Section 1 of EO number 200, then such shorter or longer period as the case may be will prevail. If the law provides that it shall take effect immediately, it means that it shall take effect immediately after publication. Pwedeng kinabukasan after the last day of publication. The effectivity provision here refers to all statutes, including those local and private laws. All right, now Article 3 provides that ignorance of the law excuses no one from compliance therewith. Okay, sounds familiar? Yes, it should be, because it is our duty to know the law. Okay, so when a law is passed by Congress, duly approved by the President of the Philippines, properly published, and consequently becomes effective pursuant to its effectivity clause or to some provision of a general law on the effectivity of statutes, the public is always put on constructive notice of the law's existence and effectivity. And this is why Article 3 and Article 2 go together. There is a need to publish these laws because ignorance of the law excuses no one. Alright, now Article 4 states that law shall have no retroactive effect unless the contrary is proved. So the law looks to the future and has no retroactive effect unless the legislature may have given that effect to some legal provisions. Ibig sabihin, dapat forward-looking ang batas, hindi na lumilingon, hindi na tumitingin sa likod, kumbaga, sa nakaraan. Alright. However, in the following instances, a law may be given retroactive effect. So number 1, when the law expressly provides for retroactivity. Okay? It must be expressly stated there because it cannot be assumed. Second, when the law is curative or remedial. Ibig sabihin, it seeks to heal or cure let's say an injustice or a wrong committed in the past. Third is when the law is procedural, because procedural laws apply even to existing actions or existing proceedings. And lastly, when the law is penal in character and it is favorable to the accused. All right. Next, Article 5. Article 5 states that acts executed against the provisions of mandatory or prohibitory laws shall be void except when the law itself authorizes their validity. Now, what is a mandatory provision of law? A mandatory provision of law is when the omission of which renders the proceeding or acts to which it relates generally illegal or void. Ibig sabihin, if it's mandatory, dapat sundin. If it's not followed, then the act is illegal or void. Now, prohibitory laws, on the other hand, are those which contain positive prohibitions and are couched in a negative or in the negative terms, importing that the act required shall not be done otherwise than designated. Kaya nga prohibition, no? It forbids something to be done. So yan po ang prohibitory laws. So kung ang mandatory law is something that requires you to do something, prohibitory law is a law that forbids you, okay, from doing something. Alright, next is Article 6, and Article 6 provides that rights may be waived unless the waiver is contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Now, waiver is the intentional relinquishment of a known right. Waivers cannot be made if they are contrary to law, public order, public policy, morals, or good customs, or prejudicial to a third person with a right recognized by law. Now, in your political law, you will remember that for a waiver to be valid, there are requisites. So, number 1, the person making the waiver or executing the waiver must be aware of the existence of the right. Okay? And second, he must voluntarily renounce the right. All right. Okay, next. Article 7 states that laws are repealed only by subsequent ones, and their violation or non-observance shall not be excused by disuse or custom or practice to the contrary. When the courts declared a law to be inconsistent with the Constitution, the former, meaning to say the law, shall be void, and the latter, meaning the Constitution, shall govern. Administrative or executive acts, orders, and regulations shall be valid only when they are not contrary to the laws or the Constitution. So, repeal of a law is the legislative act of abrogating through a subsequent law the effects of a previous statute or portions thereof. Repeal is either express or implied. An implied repeal takes place when a new law contains provisions contrary to or inconsistent with those of a former without expressly repealing them. Okay, what is of course preferred is an express repeal, and malalaman mo naman kung express repeal because in that law sasabihin naman that the provisions of Republic Act 1, 2, 3, 4 are hereby deemed repealed. something like that. And the same goes for even rules, no? Like the rules of court, for example. Recently, like 2019, the Supreme Court passed the rules on civil procedure, the amended rules on civil procedure. And in these rules, certain provisions, like for example, the provision or the rule on motions to dismiss, ni-repeal talaga siya ng 2019 amendments. All right, so those are examples of express repeals and implied repeals. But only a law can repeal another law. Okay, so even the Supreme Court cannot repeal a law. What the Supreme Court can do, of course, is to declare a law unconstitutional. So, parehas lang naman ang effect nun eh. Whether a law is repealed or a law is declared unconstitutional, parehas lang. But then when we say repeal, that is a legislative act. And the reason for the repeal is either it is contrary to the Constitution or it is contrary to maybe a public policy. So there are many causes for repeal, and it's of course addressed to the sound discretion of Congress. All right, now more on repeal, of course, in your subject called statutory construction. So marami kayo matututunan doon. Now, the Constitution is the supreme, organic, and fundamental law of the land. It is axiomatic that no ordinary statute can override a constitutional provision. Kaya nga, it's the supreme law of the land. Wala na mas mataas pa sa Constitution. Alright, Article 8. Article 8 of the Civil Code provides that judicial decisions applying or interpreting the laws or the Constitution shall form part of the legal system of the Philippines. So, in effect, judicial decisions, although in themselves are not laws, they assume the same authority as the statute itself, and until authoritatively abandoned, necessarily become, to the extent that they are applicable, the criteria which must control the actuations not only of those called upon, abide thereby, but also those duty-bound to enforce obedience thereto. That's quite a mouthful. Ibig sabihin lang, a judicial decision, if they interpret the law, they are part of the law because they give guidance to those who are mandated to abide by the law or to enforce the law. Now, lehis interpretation or interpretasyon, lehis vim obtinet. The interpretation placed upon the written law by competent court has the force of law. Alright, now Article 9 is quite interesting because it says, no judge or court shall decline to render judgment by reason of the silence, obscurity, or insufficiency of the laws. Now, judges must not evade performance of this responsibility just because of an apparent non-existence of any law governing a particular legal dispute or because the law involved is vague or inadequate. The judge must always be guided by equity, fairness, and a sense of justice in these situations. Indeed, when the law is silent or there is a gap in the law, the judge should use equity to fill that gap, okay, in order to render justice in the situation. All right. Now, Article 10. Article 10 provides that in case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. Okay, there's that presumption of regularity, that the law is always meant to do what is right and what is just. So if there is an ambiguity in the law, interpretation of the law requires fidelity to the legislative purpose. What Congress intended is not to be frustrated. Its objective must be carried out. We are not here to question the wisdom of the Congress. No, we have to obey, and we have to carry into effect the wisdom and the purpose of the legislature in enacting the law. So even if there is a doubt as to the meaning of the language employed, the interpretation should not be at war with the end sought to be attained. Alright, Article 11 provides that customs which are contrary to law, public order, or public policy shall not be countenanced. Article 12, meanwhile, provides that a custom must be proved as a fact according to the rules of evidence. Now, a custom has been defined as a rule of conduct formed by, note, repetition of acts, uniformly observed as a social rule, and legally binding and obligatory. So, pag tinanong kayo what is a custom, yan na po ang definition. So, take note of the elements there, okay? Repetitive, uniformly observed, also legally binding and obligatory. Okay, Article 13. Article 13 provides that when the laws speak of years, months, days, or nights, it shall be understood that years are of 365 days each, months of 30 days, days of 24 hours, and nights from sunset to sunrise. If months are designated by their name, they shall be computed by the number of days which they respectively have. Now, take note that in computing a period, the first day shall be excluded and the last day included. Now, this finds great importance and application in computation of reglementary periods and prescriptive periods, no, especially in actions, both civil and criminal cases. So take note of the rule, particularly the second paragraph, which states that in computing a period, the first day shall be excluded and the last day included. Gusto nyo an example? For example, today is what? September 2. Okay, September 2. 2021. Okay, so let's say you received an order from the court to file a comment to a motion within 15 days from receipt of the order. Okay, so you count the 15-day period by excluding the first day, meaning to say today, and adding the last day. All right, so you add 15 days now from September 2. Okay, so 2 plus 15, okay, so that's 17. All right, so 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. All right, so that's how you compute it. All right, now Article 14 provides that penal laws and those of public security and safety shall be obligatory upon all who live or sojourn in the Philippine territory, subject to the principles of public international law and to treaty stipulations. Okay, so if you have taken criminal law, okay, this is part of book 1, and the topic is of course the territoriality principle, that our penal laws are only effective within the territory of the Philippines. Okay, and anyone who sojourns or travels to the Philippines shall be subject to our penal laws and to our criminal law, criminal legal system. All right. Okay, now Article 15 provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. So regardless of where a citizen of the Philippines may be, he or she will be governed by Philippine laws with respect to his or her family rights and duties or to his or her status, condition, and legal capacity. So ano ba itong mga attributes or characteristics na to, no, na sinasabi na once you're a Filipino, you are subject to the laws of the Philippines. So of course, these are your personal rights and obligations, your personal capacity. Okay, so even if, let's say, in other countries, the age of capacity there is, let's say, 16, but since in our country, our age of capacity is 18, so we are so a Filipino can only acquire legal capacity to enter into contract even if living abroad if he reaches the age of 18. So another example, maybe let's say in another country, let's say a person can marry at an age of, let's say, 14, okay, but since Philippine law states that the age of capacity to marry is 18, so ganun din, no? So hindi ka pwede magpakasal sa ibang bansa if you are just 16, even if in that country the age of marrying or the marrying age is 14. All right, because of the national principle. Now, also duties, no? For example, the duty of support. So that is governed by the national law of the person. So if you are a Filipino, let's say you travel abroad, you stayed and lived in a country where there is no obligation to give support to your children, okay, you cannot avail of that exemption even if you are in that country, because what applies to you as far as, you know, the duty or obligation to support is Philippine law. And under our Philippine law, okay, a parent has the duty and an obligation, a legal and moral obligation, in fact, okay, to give support to his minor and dependent children. All right. So let's now talk about Article 16, and Article 16 provides that real property as well as personal property is subject to the law of the country where it is stipulated. No, it's where it is situated. Okay. Pasensya na, tao lang. Alright, so however, in the state and testamentary successions, both with respect to the order of succession and to the amount of successional rights and to the intrinsic validity of testamentary provisions, shall be regulated by the national law of the person whose succession is under consideration, whatever may be the nature of the property and regardless of the country wherein said property may be found. So Article 16 gives us the first paragraph gives us the rule on lex re site. In other words, the law of the place where the property is located. But the second paragraph is a nationality principle. Okay, and this is with respect to succession, especially the intrinsic validity of succession. So what is intrinsic validity? Intrinsic validity refers to rights of the person succeeding to the decedent, or the right or the prerogative of a decedent, okay, to dispose his property. So those are intrinsic validity because they refer to rights, no? But as far as the property is concerned, okay, even if they are subject to a will, okay, and the intrinsic validity of the will is expectedly or naturally governed by the national law of the decedent. But if kung merong property na involved doon, the disposition of that property, including transfer, title, and disposition of that property, shall be governed by the law of the place where that property is located. All right. Now, the third, as a commentary, of course, the law of the country where the real property is situated shall be the governing law over such real property. However, with respect to the order of succession and the amount of successional rights, whether in intestate or testamentary succession, they shall be regulated by the national law of the deceased, and this is applicable regardless of the nature of the property. O, inulit ko lang yung sinabi ko kayo na. Article 17 provides that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. When the acts referred to are executed before the diplomatic or consular officials of the Republic of the Philippines in a foreign country, the solemnities established by Philippine laws shall be observed in their execution. Now, the third paragraph provides that prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations or conventions agreed upon in a foreign country. Importante yung dalawa dito, no? Because these two paragraphs under Article 17 actually give us the rule of lex loci celebrationis, or in some jurisdictions they call it lex loci contractus. Okay, so this means that the formalities of a contract, an instrument, including wills, no, shall be governed by the law of the place where it was celebrated, where it was executed, where it was signed. But this is only with respect to formalities. Ano nga ba yung mga formalities? Formalities are those requirements that are related to the execution, yung paggawa nung papel. So, for example, if let's say in this country, of course, the sale of a movable of an immovable property or a real property must be in a public instrument as provided under Article 1358 of the Civil Code. Now, let's say that deed of sale is executed in another country, let's say country X, where it is not required to be in a public instrument, meaning hindi kailangang inotaryo. Okay? Now, yung requirement na pagnonotaryo, that's a formal requirement, and according to Article 17, the formalities of an instrument shall be governed by the law of the place where it was executed. So kung dun sa bansa na yun, kung saan pinirmahan yung deed of sale, hindi kailangang ipanotaryo yon, then that is valid here because it was valid where it was executed. Alright, now however, take note of the second paragraph, because the second paragraph states that if the document or the instrument is executed or signed or presented before the diplomatic or consular officials of the Philippines, it is as if those documents were executed in the Philippines. Because itong mga embassies na to, itong mga consular offices na to, they are extensions of Philippine territory or Philippine jurisdiction. Kaya masusunod doon yung requirement na batas ng Pilipinas. Kaya yung sinabi ko kayo na Article 1358 of the Civil Code, which applies to the execution of deeds of sale over a real property, applicable din yun dun sa papel, dun sa kontrata na pinirmahan at pinanotaryo sa embassy or embahada ng Pilipinas. Alright, yung last paragraph, this is just a reiteration of the previous provision which states that acts in violation or in contravention of mandatory and prohibitive laws shall be void, no? Now, ang sinasabi lang dito is that if it is void in the country, in this country, in the Philippines, because of some prohibitory law, hindi siya naging valid if it was executed in a country where it was allowed. Halimbawa, bigamy, of course, is illegal in the Philippines. So, yung batas na yun, applicable pa rin yun, no? Hindi na babaliwala yun just because the marriage, for example, was celebrated abroad. So, kung halimbawa doon sa ibang bansa, allowed ang bigamy or polygamy, hindi ibig sabihin allowed dito sa Philippines kasi hindi po applicable yung law sa celebration sa ganung sitwasyon because we have a prohibitive law on the matter of bigamy. Okay? Alright, so I hope that's clear. Now, the forms, as I've said, the forms and solemnities of public instruments, wills, and contracts shall be governed by the laws of the country where they are executed. Diplomatic and consular officials are representatives of the state, hence any acts or contract made in a foreign country before diplomatic and consular officials must conform to the solemnities under Philippine law. Alright, the next article is Article 18, and this is the last article under the general principles. So, in matters which are governed by the Code of Commerce and special laws, their deficiency shall be supplied by the provisions of this code. Ano ibig sabihin nun? Well, ang ibig sabihin lang nun is that the civil code shall have suppletory effect, okay, when, of course, necessary or warranted, okay, to commercial laws and other special laws on commerce, okay. So, for example, insurance code, okay, so suppletory ang character or ang effect ng civil code sa insurance code. Alright, so now let's go to the second part of the lecture, which is human relations. So in this part of the lecture, we will talk about the principle of abuse of rights, unjust enrichment, right to privacy, violation of constitutional rights, and prejudicial questions. So, let's start with Article 19. And Article 19 provides that every person must, in the exercise of his rights and in the performance of his duties, act with justice, give everyone his due, and observe honesty and good faith. So, Article 19 provides a rule of conduct that is consistent with an orderly and harmonious relationship between and among men and women. It codifies the concept of what is justice and fair play so that the abuse of right by a person will be prevented. Alright? I mean, kung lahat susundin natin to, okay, siguro wala na tayong mga kaso-kaso, no? Yan. But then again, yeah, the natural order is what? Right for everybody, you know? The natural order is chaos, so to speak. I don't want to be philosophical here, but yeah, that seems like the more natural state, no? Where there's chaos, where everyone wants to be ahead of the others. But thankfully, because of Article 19, now we know what standards to be observed, no? In the exercise of our rights and when we are performing our obligations. Alright, so Article 20 provides that every person who, contrary to law, willfully or negligently causes damage to another shall indemnify the latter for the same. Article 20 speaks of the general sanction for all other provisions of law which do not especially provide their own sanction. Ibig sabihin, if an act is against the law, okay, ngayon kung wala namang provision or sanction ang batas, no, it could be an administrative rule, no. That's why usually pag administrative rule mandatory lang yan, dapat mo lang sundin, no, pero pag hindi mo sinunod wala naman, di ba, madalas because it's just an administrative rule, lalo na kung hindi naman siya criminal law, so walang penalty yan, walang kulong yan. But then, because of Article 20, anyone who violates or contravenes a law, even if it is not a criminal law, may be liable for damages. Alright, now Article 21 states that any person who willfully causes loss or injury to another in a manner that is contrary to morals, good customs, or public policy shall compensate the latter for the damage. Insofar as Article 21 is concerned, it was designed to fill in the countless gaps in the statutes which leave so many victims of moral wrongs helpless even though they have actually suffered material and moral injury. Dito, ang na-violate, okay, what was violated here is morality, no, or customs or public policy, okay, but not the law. Okay, sabi nga nila, di ba, there is no crime and there is no law punishing it. Yes, that's true, okay? Sa criminal law, kaya di ka pwede ikulong, no, kung wala namang batas na nagbabawal sa iyo, no, at walang batas na nag-i-impose ng sanctions o penalty. But there is still a wrong. Mali pa rin siya, lalo na sa mata ng ng moralidad, sa mata ng Diyos, maybe. So we have Article 21, and this is the catch-all, no? If it is wrong, okay, but that it is not illegal, okay? It is wrong but not illegal. Okay? So dito mo ipasok sa Article 21. Okay? Ang tawag sa mga acts which are in violation of morality and therefore will fall under Article 21 are acts contra bonus mores. Alright? So tandaan nyo po yan. Acts contra bonus mores, or acts that are contrary to morals. Okay? And they may be covered by Article 21. Okay? At yung tao na gumawa ng act contra bonus mores may be liable for damages. Alright, Article 22 provides that every person who, through an act or performance by another or any other means, acquires or comes into possession of something at the expense of the latter without just or legal ground shall return the same to him. Also, Article 23 provides that even when an act or event causing damage to another's property was not due to the fault or negligence of the defendant, the latter, meaning to say the defendant, shall be liable for indemnity if through the act or event he was benefited. So no person can claim what is not validly and legally his or hers. Hence, he or she should not unduly profit on something which does not meritoriously belong to him or her. So ano principle to? Unjust enrichment. Tama, okay? So Articles 22 and 23 are your go-to provisions when someone is accused of being unjustly enriched at the expense of another. Alright, so that's worth noting. Article 22 and 23. It gives now basis for an action for reimbursement. Anong tawag doon? Action in rem verso. Alright, so please take note. Unjust enrichment is the ground. The remedy is action in rem verso. Okay? Alright. Now, Article 24 provides that in all contractual property or other relations, when one of the parties is at a disadvantage on account of his moral dependence, ignorance, indigence, mental weakness, tender age, or other handicap, the courts must be vigilant for his protection. The courts must render justice, and therefore they must be very vigilant in protecting the rights of the disadvantaged, and with the end in view that any decision will be in consonance with what is right and legal. Alright. Pag-aralan natin ng konti, baka sabihin nyo ang bias naman ng batas, kesyo mahirap or kesyo wala pinag-aralan, so dapat sa kanya ang pabor, no? That's not what the law means, no? It means that all things be equal. Hopefully everything is equal, but unfortunately we have to admit that things are not fair, no? So in case of a disparity, or in case the playing field is not fair, like someone is more intelligent than the other without the fault, of course, of the other, no, but maybe because of the circumstances of his life, no, kaya hindi siya nakapag-aral, the court should be vigilant, no, should protect the rights of the other. Okay, yung kulang sa pinag-aralan, not because biased siya, but because this is social justice, this is equity. Dapat i-level mo yung playing field. So to make sure that this person's rights are not taken advantage of by this other party who knows more and who knows better, the court must see to it, okay, that, for example, let's say there's a contract, that this contract was explained to him carefully. Okay, we have to concede na marami pa rin talaga mga Pilipino na hindi marunong mag-English, ganyan, and then siguro mababa lang pinag-aralan. A lot of contracts are in English, okay, and using very technical words or very technical terms. So Article 24 mandates, okay, that this person, must make sure that he has explained the contract to the other party, and the court must also check, no, and ask proof that in fact the contract was explained to the other party. Now, regarding poverty, regarding financial difficulties, then that can also be a test, no, of the voluntariness of the contract. Meron nga tayong saying talaga na, alam mo yung pagkagipit ka talaga, kapit ka sa patalim, and out of desperation you are an easy victim, okay, of loan sharks, okay, or other persons who would take advantage of your desperation, tapos ending mas lalo ka pang malulugmok dun sa kahirapan. All right, so that, I think that's just fair, no? It's fair because there is a need to equalize, relations, especially in civil law. All right. Now, Article 25 provides that thoughtless extravagance in expenses for pleasure or display during a period of acute public want or emergency may be stopped by order of the courts at the instance of any government or private charitable institution. Alright, thoughtless extravagance. Okay, ibig sabihin yung ba naghihirap na ang tao, bayan, or halimbawa there's a public emergency and yet some people will still flaunt, okay, and then spend extravagantly despite this emergency or despite this time of public need. Now, as the article provides, the government, the local government or any private charitable institution must initiate the act, okay, to put a stop, okay, to this thoughtless extravagance. Now, if you will reach your law on property, I think it's in your third year, meron din kayo matututunan doon, and that is called nuisance. Yung sa nuisance naman, pwede private individual mag-initiate doon. Baka pwede rin natin ipasok doon ang thoughtless extravagance because let's say the thoughtless extravagance causes annoyance or irritation, etc. So pwede pong ipatigil yun through a private nuisance. Okay, at any rate, the foundation is here. It's Article 25. Alright, now, what is Article 26? Article 26 provides that every person shall respect the dignity, personality, privacy, and peace of mind of his neighbors and other persons. The following and similar acts, though they may not constitute a criminal offense, shall produce a cause of action for damages, prevention, and other relief. So, number 1, prying into the privacy of another's residence. Number 2, meddling with or disturbing the private life or family relations of another. Number 3, intriguing to cause another to be alienated from his friends. Number 4, vexing or humiliating another on account of his religious beliefs, lowly station in life, place of birth, physical defect, or other personal condition. Okay? Now, the touchstone of every system of laws, of the culture and cultivation of every country is how far it dignifies man. If human personality is not properly exalted, then the laws are indeed defective. Ano ba yung Article 26 na yan? Ang Article 26 na yan ay yung mga batas against or laban sa mga chismoso. Yung bang hindi na lang pagtuunan ng pansin yung sarili nilang buhay, kailangan pa talaga pansinin yung buhay ng iba. Now, that is wrong in all levels, both in criminal law, okay, and also in civil law. But if criminal law is to criminal punishment, meaning may kulong doon, dito sa Article 26 is liability for damages, danyos, okay? Kung yung pang-dismiss, saka yung pang-alam will fall under any of these, okay, circumstances or situations under Article 26. Alright, let's now go to Article 27. So Article 27 provides that any person suffering material or moral loss because a public servant or employee refuses or neglects without just cause to perform his official duty may file an action for damages and other relief against the latter without prejudice to any disciplinary administrative action that may be taken. Alright, so a public official is supposed to be an agent or at least a representation of the government. Therefore, the law exacts from him or her an obligation to be very vigilant and just so that the public can be assured that the government is truly effective in servicing their needs. Indeed, public servant ka eh. So kapag may humingi ng tulong sa'yo, you have to give help. Okay, but if you refuse and that private person suffers loss or damage, then you answer to him for damages. Alright, so that's Article 27. Naku, ang dami-dami mga cases, dami-dami mga situations na naiisip natin, especially in the time of pandemic. So alam nyo na, Article 27, ayan. Okay, Article 28. Article 28 speaks of unfair competition, and it provides that unfair competition in agricultural, commercial, or industrial enterprises, or in labor through the use of force, intimidation, deceit, machination, or any other unjust, oppressive, or high-handed method shall give rise to a right of action by the person who thereby suffers damage. Now, this is necessary in a system of free enterprise. Democracy becomes a veritable mockery if any person or group of persons, by any unjust or high-handed method, may deprive others of a fair chance, okay, to engage in business or earn a living. Now, that is unfair competition. Kung there's a large business or a large entrepreneur who does everything to eliminate the competition, that's unfair competition. Okay, so meron naman tayong batas para sa unfair competition. In fact, we already have an office. It's called the Philippine Competition Commission, okay, to make sure that the free competition or the ideals of the free enterprise will be maintained in this country. But Article 28 here is the basis for action for damages. Doon sa batas natin on competition, criminal at saka administrative po ang mga sanctions doon. Okay, but Article 28 here justifies the award of damages in favor of the person or the party who suffered because of the unfair competition. Okay, Article 29. So, when the accused in a criminal prosecution is acquitted on the ground that his guilt has not been proved beyond reasonable doubt, a civil action for damages for the same act or omission may be instituted. Such action requires only a preponderance of evidence. Upon motion of the defendant, the court may require the plaintiff to file a bond to answer for damages in case the complaint should be found to be malicious. If in a criminal case, the judgment of acquittal is based upon reasonable doubt, the court shall so declare. In the absence of any declaration to that effect, it may be inferred from the text of the decision whether or not the acquittal is due to that ground. So ano ba itong mga pinagsasabi ditong proof beyond reasonable doubt tapos preponderance of evidence? Well, proof beyond reasonable doubt means the amount of proof which forms an abiding moral certainty that the accused committed the crime charged. Although hindi ito absolute certainty, only moral certainty. Meaning to say, it passes the test of doubt. Wala kang duda na siya talaga ang gumawa ng krimen. Okay, that's proof beyond reasonable doubt. Now, if the guilt of the accused is not proof beyond reasonable doubt, kasi nga masyadong mataas yun, yung bang hindi ka na mag-entertain ng doubt because the evidence has filled all those possible doubts. Okay, now that's hard to prove. But, okay, even if, okay, the court acquitted, okay, the accused due to reasonable doubt, okay, a civil action for damages may still be filed because in that case, only a preponderance of evidence is needed. Now, in your law and evidence, you will learn that the preponderance of evidence is, okay, determined by the weight of the evidence. Okay, it's not on the basis of moral certainty. It's not on the basis of what convinces or not. Well, of course, the necessary consequence of the bigger weight or the heavier weight of evidence is that it convinces more. Okay, so based doon sa ebidensya na mapipresenta. So if the plaintiff in a civil action for damages against the accused is able to prove, okay, by preponderance of evidence, by the weight of evidence that the accused committed the act, okay, although he was acquitted by the criminal court, but if he committed the act, and so that act can still fall under Article 20 of the Civil Code, which says that any person who commits an act contrary to law, okay, will be liable for damages. Okay, so pwede pa rin. Okay, yung nga lang, civil damages na, hindi na siya pwedeng kasuhan pa ulit kasi he was already acquitted, the accused was already acquitted due to reasonable doubt. And a reopening or a retrial or a refiling of that case even before the public prosecutor will result or will violate the constitutional provision against double jeopardy. Alright, now Article 30 provides that when a separate civil action is brought to demand civil liability arising from a criminal offense and no criminal proceedings are instituted during the pendency of the civil case, a preponderance of evidence shall likewise be sufficient to prove the act complained of. Okay, now Article 31 provides that when the civil action is based on an obligation not arising from the act or omission complained of as a felony, such civil action may proceed independently of the criminal proceedings and regardless of the result of of the latter. Now, this provision evidently refers to a civil action based not on the act or omission charged as a felony in a criminal case, but based on an obligation arising from other sources such as law or contract. Alright, this is criminal procedure na, no? But, sige lang, very briefly, I will discuss this. Siyempre, hindi ko na paunahan ang professor nyo sa sa criminal procedure. Okay, so, but, everything that is in the criminal procedure, of course, they are sourced from Article 30 and 31. Mas malinaw na pagdating sa rules on criminal procedure. Alright, so, Article 31 provides that any public officer or employee or any private individual who directly or indirectly obstructs, defeats, violates, or in any manner impedes or impairs any of the following rights and liberties of another person shall be liable to the latter for damages. Ayan. Any public officer or employee or any private individual who violates these constitutional rights shall be liable for damages. So ano itong mga rights na to? Well, number 1, freedom of religion. Second, freedom of speech. Third, freedom to write for the press or to maintain a periodical publication. Fourth, freedom from arbitrary or illegal detention. 5, freedom of suffrage. Dami. 6, the right against deprivation of property without due process of law, the right to a just compensation when private property is taken for public use, the right to the equal protection of the laws, the right to be secure in one's person, house, papers, and effects against unreasonable searches and seizures, the liberty of abode and changing the same, the privacy of communication and correspondence, the right to become a member of associations or societies for purposes not contrary to law, the right to take part in a peaceful or peaceable assembly to petition the government for redress of grievances, the right to be free from involuntary servitude in any form, the right of the accused against excessive bail, the right of the accused to be heard by himself and counsel, to be informed of the nature and cause of the accusation against him, to have a speedy and public trial, to meet the witnesses face to face, and to have compulsory process to secure the attendance of witness in his behalf. Number 17, freedom from being compelled to be a witness against one's self. Ibig sabihin, right against self-incrimination, or from being forced to confess guilt, or from being induced by a promise of immunity or reward to make such confession, except when the person confessing becomes a state witness. Freedom from excessive fines or cruel and initial punishment. Freedom of access to the courts. Basically, that's your Article 3, the Bill of Rights in the Constitution. So, ibig sabihin, any person, whether you're a public officer or employee or a private person who violates, these constitutional rights shall be liable, to pay damages. Alright? Now, in any of the cases referred to in this article, whether or not the defendant's act or omission constitutes a criminal offense, the aggrieved party has a right to commence an entirely separate and distinct civil action for damages and for other relief. Such civil action shall proceed independently of any criminal prosecution if the latter be instituted and may be proved by a preponderance of evidence. Okay, so again, criminal procedure. Sa criminal procedure, matututunan nyo doon o malalaman nyo yung independent civil actions. Isa to, Article 33, isa siya sa mga independent civil actions. Okay? Now, the indemnity here shall include moral damages, and also exemplary damages may also be adjudicated. The responsibility herein set forth, however, is not demandable from a judge unless his act or omission constitutes a violation of the penal code or other penal statute. So, syempre, exempted ang judge dyan. So, how can you say that the judge has violated the right when the judge is only doing his job? So, for a judge to be deemed as having violated the constitutional right of a person, it must first be proved to be criminal in character. Okay, so yung civil damages hindi siya automatic, unlike in the case of public officer, employee, or private person na pwede agad i-demanda ng damages by the mere act of trampling on these constitutional rights. But for a judge, if the judge is in the performance of his duties and functions, the law treats it differently. A judge is doing a legally mandated job, so it's not supposed to be treated lightly as a violation of constitutional rights. If, for example, natalo sa kaso yung complainant. But if it were a criminal case, Okay, for example, rendering obviously illegal judgment or unlawful judgment, then yun, siguro pwede pa yung maging basis of an action for damages under Article 33 of the Civil Code. Okay, now the creation of an absolutely separate and independent civil action for the violation of civil liberties is essential to the effective maintenance of democracy for these reasons. Okay, so remember why independent civil actions are justified. Number one, in most cases, the threat to freedom originates from abuses of power of government officials and peace officers. Number two, even when the prosecuting attorney filed a criminal action, the requirement of proof beyond reasonable doubt often prevented the appropriate punishment. Diba? Third, direct and open violations of the penal code trampling upon the freedoms named are not so frequent as those subtle, clever, and indirect ways which do not come within the pale of the penal law. Kaya at least merong remedy, and that is a civil action for damages. Now, let's look at Article 33. And Article 33, in cases of defamation, fraud, and physical injuries, a civil action for damages entirely separate and distinct from the criminal action may be brought by the injured party. Such civil action shall proceed independently of the criminal prosecution and shall require only a preponderance of evidence. Again, katulad nung Article 32. Article 32 also justifies an independent civil action. But the ground there is violation of constitutional rights. Article 33 naman, defamation, libel, yan at physical injuries, no? So kasama yan. You can file an independent civil action. Okay, independent civil action kasi lagi ko binabagets, lagi ko naman tinuturo sa criminal procedure, baka isipin nyo, ano ba yan, ba't di nila kasi i-discuss? Okay, siyempre, i-discuss ko lang yung kaya ko. Okay, so pag sa independent civil action, that means that it can be filed separately, no, in another court. Okay, because normally as the civil liability or the prayer for damages will be instituted together with the criminal case. Pero if it's under Article 32, 33, Article 2176 or your quasi-delict, then pwede yan independent. Pwede po yan i-file in a separate court, no? And regardless kung ano ang resulta sa criminal case, pwede pa rin to civil case, tuloy pa rin to. Unlike when the civil case is incorporated in the criminal case, of course, syempre, hihintayin mo talaga kung ano ang resulta sa criminal case. And if you win, good. I mean, if you are the private complainant, if you win in the case, then that's good because most probably you will also get a judgment in your favor, okay, ruling on your prayer for damages. Pero syempre, pag natalo ka, mahirap na, baka pati yung prayer for damages mo ma-deny na rin. So, but in the case of an independent civil action, it's called independent. It's not called independent for nothing. Kaya nga siya tinawag na independent. It will not be affected by the result of the criminal case. Alright, now Article 34 provides that when a member of a city or municipal police force refuses or fails to render aid or protection to any person in case of danger to life or property, such peace officer shall be primarily liable for damages, and the city or municipality shall be subsidiarily responsible therefore. The civil action herein recognized shall be independent of any criminal proceedings, and a preponderance of evidence shall suffice to support such action. Yan. So, isa pa independent civil action. So, 32, 33, 34, 2176. Now, Article 35 provides that when a person claiming to be injured by a criminal offense charges another with the same, for which no independent civil action is granted in this code or any special law, but the justice of the peace finds no reasonable grounds to believe that a crime has been committed, or the prosecuting attorney refuses or fails to institute criminal proceedings, the complaint may bring a civil action for damages against the alleged offender. Such civil action may be supported by a preponderance of evidence. Upon the defendant's motion, the court may require the plaintiff to file a bond to indemnify the defendant in case the complaint should be found to be malicious. If, during the pendency of the civil action, an information should be presented by the prosecuting attorney, the civil action shall be suspended until the termination of the criminal proceedings. Alright, ito yung sasabi ko na when the civil case is supposed to be incorporated in the criminal case. So, for example, it's a crime of estafa. So, syempre yung estafa kasi may involved na amount yan eh. May involved na damage, na monetary damage. But estafa is a criminal case. It's an offense. It's a crime under the revised penal code. So, it is standard practice that the civil liability is instituted together with the criminal case. Now, let's say the act constituting estafa was already the subject of a civil case for damages. Okay, so let's say an action to collect a sum of money plus damages because of the fraud, because of the fraud, misrepresentation committed by the defendant who later on becomes an accused in a criminal case for estafa under the revised penal code. So in this case, kahit nauna yung civil case for civil damages, that will have to be suspended, and the criminal case will be awaited under Article 35. Okay, but in your again criminal procedure, meron pong mga dynamics dun, like for example when the criminal case is filed, and then at the preliminary hearing, of course the accused or the private complainant may be asked kung ano ba ang gusto mo. Do you want to institute the or do you want to file a separate civil case, or do you want it to be instituted here? But normally, if no question is made and no manifestation is, or if no question is asked or no manifestation is made by the private complainant, then the civil case will be incorporated. Okay, now the only way for that civil case to be filed independently is, number one, if it was filed before the criminal case, or second, if the private complainant reserves, okay, the right to file it separately. Basta in either case, kung na-file man yan ahead, or kung halimbawa may reservation to file it separately, dapat matapos muna yung criminal case. Alright? So, when a criminal case is instituted, the civil action for the recovery of civil liability arising from the offense charge shall be deemed instituted with the criminal action, unless the offended party waives the civil action, reserves its right to institute it separately, or institutes a civil action prior to the criminal action. Alright, like what I said. Alright, now Article 36, okay, speaks of prejudicial questions. Ano ba itong prejudicial questions? By the way, prejudicial questions, which must be decided before any criminal prosecution may be instituted or may proceed, shall be governed by the rules of court which the Supreme Court shall promulgate, and which shall not be in conflict with the provisions of this code. So a prejudicial question is one that arises in a case, the resolution of which is a logical antecedent of the issue involved therein, and the cognizance of which pertains to another tribunal. There are therefore two essential elements of a prejudicial question. First, the civil action involves an issue similar or intimately related to the issue raised in the criminal action, and number two, the resolution of such issue determines whether or not criminal action may proceed. Alright? So, well, from the top of my head, naisip ko na prejudicial question. Halimbawa, a person is being charged with, let's say, falsification of a public document. Okay? But then, according to him, he cannot be sued for falsification because the document, or he did not give his consent to the document. Okay, so if he files a case now to cancel the document on the ground of fraud or lack of consent, and that case has already been filed, then that is a prejudicial question to this criminal case, because if it can be proved in that civil case that that document is falsified or he did not give his consent, then his culpability now in the criminal case is now put in question. Okay, kasi hindi naman pala siya ang nag-falsify nun, according as may be determined in the civil case. Alright, so those are the textual discussion of Article 1 to 36 on the general principles, as well as the chapter on human relations in the Civil Code. The first two chapters in the subject of persons and family relations. But wait, there's more, because we will be talking about doctrinal rulings, or what we call the canonical rulings, the decisions and the pronouncements of the Supreme Court on these topics. Alright, so these are the doctrinal rulings. So we will start with the case of Estipona versus Lobrigo, GR number 226679, August 15, 2017. And this talks about the difference between substantive law and remedial law. So here, substantive law was defined as that part of the law which creates, defines, and regulates rights, or which regulates the right and duties which give rise to a cause of action. It is also that part of the law which courts are established to administer. Meanwhile, adjective or remedial law prescribes the method of enforcing rights or obtain redress for their invasions. Now, this is important kasi kayo na, di ba, meron tayong pinag-usapan yung retroactivity of laws. So, kung procedural law yan, pwede yang maging retroactive. Pero kung hindi yan procedural law, kung substantive law yan, dapat prospective. Always looking forward. So, yan. That's the difference. Okay, next is the case of Tañada versus Tuvera, L63915, April 24, 1985, on effectivity of laws. So this is about the publication requirement. So laws shall take effect 15 days following their publication in the official gazette or in a newspaper of general circulation. The law may provide a longer or shorter period of effectivity after publication. The rule that ignorance of the law excuses no one from compliance therewith is premised on the knowledge or notice of the law. Without such notice and publication, there would be no basis for the application of the maxim. It would be the height of injustice to punish or otherwise burden a citizen for the transgression of a law which he had no notice whatsoever, not even a constructive one. Ayan. So, yun sasabi natin, magka-relate, no? Related ang law Article 2, yung provision on the publication of laws, as well as Article 3 of the Civil Code on ignorance of the law. Okay, that ignorance of the law excuses no one. Alright, now, next case is Commissioner of Customs versus Hypermix, GR number 179579, February 1, 2012, on effectivity of administrative rules. So here, the Supreme Court held that when an administrative rule is merely interpretative in nature, its applicability needs nothing further than its bare issuance, for it gives no real consequence more than what the law itself has already prescribed. When, on the other hand, the administrative rule goes beyond merely providing for the means that can facilitate or render least cumbersome the implementation of the law, but substantially increases the burden of those governed, it behooves the agency to accord at least to those directly affected a chance to be heard, and thereafter to be duly informed before that new issuance is given the force and effect of law. Thus, under Section 3, Chapter 2, Book 7 of the Revised Administrative Code, every agency shall file with the University of the Philippines Center 3 certified copies of every rule adopted by it. Rules in force on the date of the effectivity of the code which are not filed within 3 months from that date shall not thereafter be the basis of any sanction against any party or persons. Alright, so take note, aside from the publication requirement as stated in Article 2 of the Civil Code and as further amended by EO number 200, okay, dated 1987, year 1987, and as explained by the case of Tañada versus Tuvera, when it comes to administrative rules, these administrative rules must also be deposited with the University of the Philippines Law Center for them to be effective. Alright, now the next case is Co versus Court of Appeals, GR number 100776, October 28, 1993, on prospectivity of laws. So, laws shall have no retroactive effect unless the contrary is proved. Next, penal law shall have a retroactive effect insofar as they favor the person guilty of a felony who is not a habitual criminal. The prospectivity principle has also been made to apply to administrative rulings and circulars. And lastly, the principle of prospectivity has also been applied to judicial decisions, which, although in themselves are not laws, they are nevertheless evidence of what the laws mean. So kaya they are treated like laws, and therefore they should also be prospective in effect. Alright, the next case is Barcelote versus Republic, GR number 222095, August 7, 2017. And this case refers to acts executed against provisions of mandatory and prohibitory laws. So, a birth certificate executed against the provisions of the law respecting the registration of birth of illegitimate children is void. Okay, because we have rules on registration of illegitimate children. So remember that acts executed against the provisions of mandatory or prohibitory laws shall be void. Alright, the next case is Reyes versus Lim, GR number 134241, August 11, 2003. And this speaks of the silence of the law. Okay, yung sasabi natin, a judge should not refuse to render judgment. The judge can, give or render the most just judgment possible. Okay, so that's Article 9 of the Civil Code. And Article 9 of the Civil Code expressly mandates that courts must make a ruling despite the silence, obscurity, or insufficiency of the laws. This calls for the application of equity Okay? Which fills the open spaces in the law. Wala naman dapat talaga butas sa batas eh. At kung meron man, equity will fill that hole. Alright, the next case is Park versus Liwanag, GR number 248035, November 27, 2019. And it speaks of right and justice as intent of the law. In case of doubt in the interpretation or application of laws, it is presumed that the lawmaking body intended right and justice to prevail. So in this case, what was involved was the adoption of a minor child. So in adoption proceedings, the welfare of the child is of paramount interest. A relaxation of the rules of procedure is necessary to promote the best interest of the adopted child. Alright, so the next case is Yao Ki versus Ida C. Gonzalez, L-55960, November 24, 1988, and this speaks of customs. Okay, ang involved dito yung Chinese customs on marriage. So, here, a custom is a rule of conduct formed by repetition of acts uniformly observed or practiced as a social rule, legally binding and obligatory. However, a custom must be proved as fact according to the rules of evidence. It cannot be assumed. Alright, next is Del Socorro versus Wilson, GR number 193707, December 10, 2014. And this speaks of the nationality principle. Article 15 of the Civil Code provides the principle of nationality. Insofar as Philippine laws are concerned, especially the provisions of the Family Code on support, the same only apply to Filipino citizens. By analogy, the same principle applies to foreigners such that they are governed by their national law with respect to family rights and duties. Remember, nationality principle, kung hindi naman pala required sa bansa mo, then it's not required here. However, this case is different because even if the laws of the Netherlands neither enforce a parent's obligation to support his child nor penalize the non-compliance therewith, such obligation is still duty enforceable in the Philippines. Why? Because it would be of great injustice to the child to be denied of financial support when the latter is entitled to. All because the national law does not provide for it. So here, what should prevail is the best interest of the child over the nationality principle. Alright, so magandang case to. Basahin nyo to, especially if you're also taking conflict of laws. Okay? Next is Bellis versus Bellis, L-23678, June 6, 1967. So this case talks about nationality principle versus prohibitive laws. So, under Article 16 and 1039 of the Civil Code, capacity to succeed is to be governed by the national law of the decedent. Under Article 17 of the Civil Code, prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated or by determinations, conventions agreed upon in a foreign country. However, Article 16 and 1039 of the Civil Code prevail over Article 17. Whatever public policy or good customs may be involved in our system of legitimes, okay, Congress has not intended to extend the same to the succession of foreign nationals. Okay? So, maganda case to because here, kinwalify ng Supreme Court na even though we have a law on legitimes or yung portion ng estate that's reserved for compulsory heirs like mga legitimate children, illegitimate children, and the spouse, pero pagdating talaga sa succession to a foreign national, his national law will prevail. Okay? And Article 17 does not have the effect of modifying that Article 16. Article 16 trumps Article 17. Alright. Next is Orion Savings Bank versus Shijay Kani Suzuki, GR number 205487, November 12, 2014. And the topic or the issue here is Lex Loci Recite. Real or immovable property is exclusively subject to the laws of the country or state where it is located or situated. All matters concerning the title and disposition of real property are determined by the Lex Recite, which can alone prescribe the mode by which a title can pass from one person to another. Hello, torrent system, or by which an interest therein can be gained or lost. So the general principle includes all rules governing the descent, alienation, transfer of immovable property, and the validity, effect, and construction of wills and other conveyances. Okay? Alright, so remember that. Okay, next is Ardiente versus Pastor Fide, GR number 161921, July 17, 2013, on abuse of rights. So, human relations na to. So, first rule to note is that the exercise of a right must be in accordance with the purpose for which it was established. and must not be excessive or unduly harsh, and there must be no intention to harm another. In this case, water supply was disconnected to compel compliance with the agreement to transfer the water utility account. The court ruled that the disconnection was tainted with intention to cause harm or prejudice. Alright, the next case is Parents Marketing versus Court of Appeals, GR number 126486, February 9, 1998, on, again, abuse of rights. So, there is an abuse of right when it is exercised for the purpose of prejudicing or injuring another. When the objective of the actor is illegitimate, the illicit act cannot be concealed under the guise of exercising a right. Okay? Lagi kong inuulit-ulit na, just because you can doesn't mean you should. Okay? Kasi if you insist on that, then you might just be liable for damages because of abuse of right. Alright, the next case is California Clothing versus Quiñones, GR number 175822, October 23, 2013. Still on abuse of rights. So even if the right exists, the question is whether such right was exercised in good faith or the defendant went overboard. Good faith is a state of mind which is manifested by the acts of the individual concerned. It consists of the intention to abstain from taking an unconscionable and unscrupulous advantage of another. So yun po ang good faith. Okay, lack of intent to take advantage or prejudice another. Alright, the next case is a very popular case. I think every law student since the 1990s, okay, knew of Bax versus Court of Appeals. Alright, so a breach of promise to marry per se is not an actionable wrong. However, where a man's promise to marry is in fact the proximate cause of the acceptance of his love by a woman and his representation to fulfill that promise thereafter becomes the proximate cause of the giving of herself unto him in a sexual congress, proof that he had in reality no intention of marrying her and that the promise was only a subtle scheme or deceptive device to entice or inveigle her to accept him and to obtain her consent to the sexual act, that could justify the award of damages pursuant to Article 21, not because of such promise to marry, but because of the fraud and deceit behind it and the willful injury to her honor and reputation which followed thereafter. Ayan, so kayo mga lalaki, wag kayo masyadong mabilis, no? Do not promise someone marriage, okay? Of course, when I say someone, babae yun, okay, so do not promise a woman marriage and then only to use that promise to get her to bed. Okay, then later on say, I changed my mind. Okay, because although that is not, yung breach of promise to marry is not really a breach of a civil obligation, but what you did, now that's contrary to morals, according to Bax versus Court of Appeals, and therefore falls under Article 21 of the Civil Code, and you can be held liable for damages. Alright, next case is Medel versus Court of Appeals, GR number 131622, November 27, 1998, on excessive and exorbitant interest. So the interest of 5.5% per month or 66% per annum stipulated upon by the parties in the promissory note is iniquitous or unconscionable and hence contrary to morals. Act contra bonus mores, if not against the law. The stipulation is void. The courts shall reduce equitably liquidated damages, whether intended as an indemnity or a penalty, if they are iniquitous or unconscionable. Under the circumstances, interest of 12% per annum and an additional 1% month penalty charge as liquidated damages may be more reasonable. Alright, so although wala na tayong usury law and the parties can stipulate on the interest, but the court has the power to reduce it, okay, but not entirely delete it because the parties agreed to impose an interest on the obligation, but the rate, okay, can be reduced or tempered by the courts if the same is iniquitous or unconscionable. Alright. Next is Landback versus Ong, GR number 190755, November 24, 2010, on unjust enrichment. So, what is unjust enrichment? Unjust enrichment exists when a person unjustly retains a benefit to the loss of another, or when a person retains money or property of another against the fundamental principles of justice, equity, and good conscience. There is unjust enrichment under Article 22 of the Civil Code when, number 1, a person is unjustly benefited, and number 2, such benefit is derived at the expense of or with damages to another. In order that an action in rem verso may prosper, the following conditions must concur. Number 1, that the defendant has been enriched. Number 2, that the plaintiff has suffered a loss. Number 3, that the enrichment of the defendant is without just or legal ground. And number 4, that the plaintiff has no other action based on contract, quasi-contract, crime, or quasi-delict. Alright, so take note of the meaning of a just enrichment. Take note also of the requisites for an action in rem verso, which is, of course, known also as an action for reimbursement. Alright, next is, spouses Hing versus Chua Choi, GR number 179736, June 26, 2013. And it speaks of the right to privacy. So Article 26.1 of the Civil Code protects an individual's right to privacy and provides a legal remedy against abuses that may be committed against him by other individuals. Now, the individual's right to privacy under Article 26.1 of the Civil Code is not confined to his house or residence, as it may extend to places where he has the right to exclude the public or deny them access. A business office is entitled to the same privacy when the public is excluded therefrom, and only such individuals as are allowed to enter Mikang. So alam niyo na, huwag kayo masyado naninilip kasi alam mo, may nakikita kayo nang nagaganap doon sa salamin sa kabilang building. Stop staring, just mind your own business. Alright, next case is Tan versus Valeriano, GR number 185559, August 2, 2017, on malicious prosecution. So, the award of damages arising from malicious prosecution is justified if and only if it is proved that there was a misuse of abuse of judicial processes. The mere act of submitting a case to the authorities for prosecution does not make one liable for malicious prosecution. So, remember that just because you won the case and let's say the plaintiff lost the case, it doesn't mean that you can immediately file an action for malicious prosecution against your opponent, because the mere filing of a case which later on was dismissed, that doesn't give rise to a malicious prosecution. As stated here, it can only prosper if and only if that the plaintiff, the losing party, misused or abused the judicial processes. But if it's a legitimate concern, a legitimate claim, and the process provided by the rules of court was followed, then how could you say that the other party maliciously prosecuted you? You were given the benefit of the doubt. You were given a day in court. Kaya nga nanalo ka eh. Diba? So there was no malicious prosecution. Alright, the next case is Lim versus Ponce de Leon, L-22554, August 29, 1975, on unreasonable search and seizure committed by a public officer. So, a person whose constitutional rights have been violated or impaired is entitled to actual and moral damages from the public officer or employee responsible therefore. To be liable under Article 32 of the Civil Code, it is enough that there was a violation of the constitutional rights of the plaintiffs, and it is not required that the defendant should have acted with malice or bad faith. Alright? So take note, Lim versus Ponce de Leon speaks of a public officer violating the constitutional right of the plaintiff. Now, in the next case, this is a private individual who violated the constitutional rights of the plaintiff. So the case is Silahis International versus Soluta, GR number 163087, February 20, 2006. Article 32 of the Civil Code holds not only public officers but also private individuals civilly liable for violation of a person's constitutional rights. It is not necessary that the defendant should have acted with malice or bad faith. It suffices that there is a violation of the constitutional right of the plaintiff. Hence, the private individual here was also held liable for civil damages. Alright, so those are the cases on Articles 1 to 36, and of course before that, of course, our textual discussion of the general principles and the chapter on human relations under the Civil Code. Alright, now I would like to give due credit, of course, to my reference for this lecture. Most of the discussions here were taken, and most of the cases were also cited from the book of Persons and Family Relations by Dean Mel Santamaria. So thank you, Dean, and I hope to see you at FEU. Alright, so that's about it. Thank you very much for watching. I hope may natutunan kayo sa lecture na to. And I'd like to give a shout out to all my students in Persons and Family Relations from the Manila Law College. Hi to all of you, and I hope to see you in the next meeting. Alright guys, so that's it from me. This is the House of Law. If you like this video, please drop a like. If you haven't subscribed to my channel and you like what I'm doing here, please subscribe to my channel to support me, and please click that notification bell so that you will be notified in case I upload a new video. So until next video, watch out for the episode 9 of the Justice Leon and Jurisprudence next week. So till then, I'll see you next time. Laging tatandaan, isip ay buksan, alamin ang batas. Bye guys!